Hello, and welcome to video number 3 for our course on the legal environment. This is a little bit more detail on some of the broad parameters of information that were presented in the second video where I talked about government structure in general, all of which move together to make laws in the United States, whether it be in the state or the federal level, whether we're talking about the executive branch, the legislative branch, or the judicial branch. So video 2 gave you kind of a broader set of understanding, or perhaps a reminder, I hope, for the way in which the American government system works. Here we're going to discuss more specifically the role or the roles of the court. While this class is about business law, for the most part we don't spend a lot of time talking about the ways in which laws are made, whether that be by the executive or by Congress, but rather we spend more time talking about the kinds of conflicts in which individuals and businesses find themselves and the role that the court plays in resolving those conflicts. So we're going to spend a little bit more detail talking about that here. By and large, we were talking about both state and federal level and a role the courts play. I'll make some differentiation, but to a large extent, these rules apply whether or not we're talking about state courts, state of Pennsylvania, state of New Jersey, or whether we're talking about the federal courts. Okay. There are two essential things that we talked about in video number 2 about the structure of the U.S. governmental system that help to shape our understanding of the specific role of the court. One was federalism, right? That we have 52 different judicial systems, maybe only 51 if you consider D.C. to be part of the federal system. But that means that we need to think about laws, whether or not they're coming from the state and whether or not it's your own state court that is going to do the application of the law, or whether or not it is the federal law and federal courts. Jurisdictional questions about where those lines fall can be pretty complicated, but it is important to know that that distinction exists. And state courts are the final voice on their own state laws, on their own state constitution. So if there's a statute enacted in Harrisburg, and that statute deals with environmental regulation, and it deals with business and industry in Pennsylvania, then it is the state courts that interpret that statute and apply it to specific conflicts. The federal courts don't get involved. Unless, and this is an important unless something that the state does conflicts with the U.S. Constitution. In that case, the supremacy clause of the U.S. Constitution dictates that federal power, federal law is supreme, and the state law must fall. But up until that point, in many issues of regulations of business and industry that occur in the United States today are state laws, and those are carried out and decided by state courts. When it comes to federal laws, federal treaties, the United States Constitution, the United States courts are the definitive voice on that, with the United States Supreme Court sitting at the top of that system. So it's just important to bear in mind that we have both federal and state courts that are making decisions depending on where the law originates. There's also, of course, the question of separation of powers, or as the famous presidential historian or political scientist Richard Neustadt once called it, separate institutions sharing powers, because no one institution alone can make law or make policy. They must work together in order to make that occur. And so the question is, what role do the three branches play? The legislative branch, whether that be Congress or your state legislature, makes the law. The executive branch, whether that be the president or your governor, carries out the laws. And the judiciary, which is what we're concerned about here, applies the laws to specific conflicts. Laws are written in general terms, but conflicts happen in specific instances. And courts take those specific instances and, in fact, apply them. Take the conflict and apply the law in those specific instances. And in so doing, they must invariably interpret the law, because laws are written in general terms, not for specific conflicts. And so the job of the court is largely to think about the way in which a broadly or generally constructed piece of legislation, statute, or regulation may apply to a specific circumstance. And that is, in fact, the role that the courts play in the system. One other thing about court structure that we hadn't discussed previously, but that is important to remember, is that the judiciary is very much a hierarchical system that runs by a system of stare decisis, where previous decisions dictate what future decisions would say. So that, for instance, a court sitting in Sunbury, Pennsylvania, can't determine independently what a statute means. It must follow what guidance has been given from previous decisions, both of that court itself as well as of higher courts. And lower courts are always bound by the decisions of higher courts. Okay. Final decisions on federal law rest with the United States Supreme Court, on state law with state Supreme Courts. On the federal level, the United States Supreme Court is the final voice on what, in fact, the Constitution and the laws of the United States mean, at least final at that point in time. That doesn't mean it can't be changed, and we'll talk about that in a moment. So the first role that the courts play is that they interpret and apply laws. I mentioned this already, but this applies whether a law is one that is passed by a legislature, whether it was a regulation enacted by an administrative agency, and we talk a little bit more about those in Chapter 5 of your text, or perhaps even more commonly in business law than in some other fields, there are common law principles that have been used for hundreds of years that have been passed down over the generations, which have often come both from statute but also from past court practices. And those past practices then must be interpreted in light of an existing conflict. There are hundreds of examples found throughout your text. The business scenarios and case problems at the end of each chapter. There are cases that are embedded throughout each chapter that talks about the kinds of conflicts that have arisen and the way courts have resolved them. Just very broadly, I pulled out a few to give examples. If it's a federal law, statute, legislation, there's a case that's talked about in Chapter 16 that asks the question of whether or not when wait staff pool their tips, which may result in lowering of wages for some, whether that is a violation of federal minimum wage laws. Well, I'm sure the federal minimum wage laws do not specifically speak to tip pools, but in fact, somebody must decide that question if the conflict is raised before the court, and that is the job of the court to do. You may have a state statute, so that in Chapter 7, there's a case talked about at the end of that chapter in which an individual was accused of credit card theft, and the question was really whether or not the way in which Arkansas law defined credit card theft, whether or not this action of this individual qualified as such. Again, that would be up to finally the Arkansas State Supreme Court to make that decision as to whether or not the specific circumstances of that case are affected by the broader law. Administrative regulations, major impact on business and industry in the United States, both on the state and the federal level. Chapter 5 gives a variety of examples, but one of them is one about greenhouse gas emissions, an important question in regulation these days, and the question of how far the power of the EPA to regulate those gases actually goes. Right? And then there are common law principles, standards that have been applied over time in purposes particularly around contract law and around tort law, that have been passed down and modified slightly from generation to generation, but the general principles have remained the same. So that in Chapter 12, you have a question about contract. An implied contract is alleged. How do you know if that an implied contract has actually been entered into? And there are a variety of outlines, parameters, guidelines for determining that have been established predominantly by past court decisions. Some of that has been put in the form of statutes, but a lot of this is common law principles that have been enacted through, that have been passed down through past court precedents. In all of these instances, it's important to remember that the Supreme Court of either the state or the federal level is not the final voice. So that if Congress passes a piece of legislation, the court interprets it in a specific way, and Congress doesn't like that, they can rewrite the legislation. They can write legislation to overturn a common law principle, which has certainly been done many times in the past. So that if some sort of standard that has been used to determine whether or not an implied contract exists has been used by the courts, and Congress determines we don't like that, or Pennsylvania doesn't like the way in fact that happens in regard to contracts in Pennsylvania, they can enact a piece of legislation that specifically defines how we know when an implied contract exists. Right? So in all of these instances, while the court has a degree of power in making law, they don't have a final voice. The final voice still rests with those people that we elect to be making any of those decisions. The second role is one where they are more powerful. Where their voice is more final. The reality is that in a system of a rule of law, we expect the actions of all individuals, government individuals and others, to be bounded by law. And the highest law in the United States is in fact the United States Constitution. The United States Constitution, we only have one. States also have their own constitution, and state government officials are bound by that state constitution and by the federal constitution. All federal officials are bound by the federal constitution. And when conflicts arise that raise constitutional questions, so that if an action of an executive or a legislative official violates standards established by the Constitution, then somebody needs to determine A, whether or not that in fact has happened, and B, if so, who wins. And the judiciary has been granted that power in the form of a power that we call judicial review, which is the power that the courts have to determine if an act of government as an institution comports with the Constitution. So that if Congress enacts a piece of legislation that may in fact, for instance, instance conflict with the free speech clause of the First Amendment, then in fact the court may determine that it's unconstitutional and strike it down. Meaning that despite the fact that a majority of Congress might have wanted that piece of legislation, the court says, no, you cannot do that because it violates the Constitution. Flag burning statute is a primary example of this, where both the federal government and the state of Texas had both enacted flag burning statutes which made it a crime to burn the United States flag. The Supreme Court in both cases said you can't do that. The free speech clause of the First Amendment of the United States Constitution protects speech, even speech that we find unacceptable, and therefore to enact legislation that limits speech in that regard must be struck down as being unconstitutional. In that instance, the court actually is speaking with a final voice. I present here on the slide some past examples. There are a variety of them found throughout your text. Free speech and questions of defamation as a media organization, for instance. How far can you go in saying things that might be defamatory and when does that go too far, and when does the First Amendment allow some sort of limitation? The Adirondack Construction Company is about minority set-asides. Can the federal government require that folks with whom they contract give a certain percentage of their work to minority-owned businesses, or is that somehow a violation of the Equal Protection Clause of the 14th Amendment? Does the Commerce Clause of Article 1, Section 8 in the United States Constitution give the U.S. Congress the authority to enact certain kinds of legislation? Labor relations had historically been regulated by the states. The federal government starts to do so in the 1930s and 40s. Was that in fact allowable? The Supreme Court at that point said yes. We saw another question more recently about that, and this is the question of the degree to which either the taxing power or the commerce power of the federal government enable them to regulate the healthcare industry under the Affordable Care Act. Obviously, more contemporary controversy surrounding that. And when the Supreme Court reaches a decision, it is the final decision, at least for that point in time. It's why I call judicial review the ultimate power. Again, if Congress disagrees with the court in the meaning of a statute or the development of a common law principle, or if an administrative agency disagrees in regard to a regulation and says, no, court, you decided that wrong, they can pass clarifying legislation or a new regulation that is clearer. Right? When it's a constitutional question, though, that is not possible because the court is the final voice on whether or not something is constitutional. So Congress can't just turn around and say, well, I don't care if you don't want us to enact a flag burning statute, we're going to do it anyway. Because the reality is that statute by its very nature conflicts with the Constitution, and the Constitution is in fact the supreme law of the land. It doesn't mean that there's no way of changing it, because there are ways, but they're much more cumbersome and much less likely to take effect. So that if the court decides a case, they could also decide 60 years later that perhaps they interpreted the Constitution the wrong way. So the classic example that people will point to in this regard is Plessy versus Ferguson. If you know anything about that case, in 1896, the United States Supreme Court determined that segregation was in fact okay under the United States Constitution. 60 years later, in 1954, in Brown versus Board of Education, the Supreme Court says no, segregation is not acceptable under the Equal Protection Clause of the 14th Amendment of the United States Constitution. So in that period of time, our understanding of the meaning of the Constitution had changed, and therefore, effectively, Plessy was overturned. But that does not happen very often, and even when it does, if people are looking for change, they probably don't want to wait 60 years. The other way in which change can occur, which has occurred 27 times in our nation's past, is through a constitutional amendment. That requires, though, 2/3 of members of both houses of Congress and 3/4 of all states to agree, something that is very difficult to achieve. Perhaps that's why we've only had 27 of them since our Constitution was written in 1787. And the first 10 of those were the Bill of Rights in 1791. So really only 17 from that point of time on amendments have been written to change the United States Constitution. So once the court determines that something is unconstitutional, that is a great power, and they have the final voice until one of these two changes might occur. Right? So they both interpret statutes and apply them, but they also have the power of judicial review. Is the Supreme Court a non-democratic institution? Some might say yes. The reality is that most of the time we think that laws should be enacted by those people we elect to do so, right? So Congress will enact a piece of legislation, or your state legislature will enact legislation because that's what we elected them to do. In this instance, we actually have the courts telling elected legislatures that you can't do what you want to do, even if the people who elected you want you to do that, right? When we talk about the federal courts, this becomes even more challenging from a democracy perspective because judges on both lower courts and the appellate court in the United States Supreme Court are nominated by the president and confirmed by the Senate. They are independent in that they have lifetime appointments unless they are impeached, and no justice of the United States Supreme Court has ever been impeached in our nation's history. This was all done intentionally, both the selection process and the life tenure, to ensure that courts could be somewhat independent and removed from the political fray. Whether or not they still are removed, whether or not they ever were, perhaps is another question. Certainly recent controversies over Supreme Court nominations, Neil Gorsuch, Brett Kavanaugh, show that there's some political nature to Supreme Court appointments, and people are pretty aware of that. But there's still some understanding that perhaps the kind of political role the courts play is somewhat different from what is played by the executive and the legislative branches. Constitutional questions, though, give courts a great degree, especially the Supreme Court, of policymaking power. You'd have to take further courses on the courts to get into more engaged debate about whether or not that, in fact, is an acceptable use of power. I think it often depends on whether or not you like the decision the court is coming down with or not. So, does this matter in the long run? What role do the courts play? Whether they're determining questions of constitutionality or only interpreting statutes and applying them to specific conflicts. To give a sense of more contemporary significance, I did a Google search and found this article from October 2017 in Fortune magazine. If you want to look at the PowerPoint slides yourself, the article is hot linked so that you can read it. But it listed 5 very important cases that were coming before the United States Supreme Court last term that involved statutory or regulatory interpretation or constitutional questions, all of them involving and affecting businesses of different types and sizes. So every day, every year, the Supreme Court is making decisions that affect business and industry in the United States. You can read about these on the screen here, and you can read the article yourself if you want to explore this more fully. And this is just those cases coming to the United States Supreme Court. The large majority of conflicts in the United States on a regular basis never make it to the Supreme Court. They're decided by local courts, both federal and state, and by courts of appeals, both federal and state. Hundreds of thousands of cases are decided every year that involve courts looking at specific conflicts in which people are involved and applying the law to that specific conflict, interpreting the law to see how it applies, and carrying it forward. Okay. So the takeaways from this video, courts have major policy-making powers in the United States, and that is often applied in interpreting laws and applying them to specific conflicts and cases that involve business and industry in the U.S. All courts have these powers, lower courts, trial and intermediate appellate courts, as well as Supreme Courts. However, because of the notion of vertical stare decisis or precedent, lower courts are always bound by what the court that comes above them has decided. So it is the Supreme Courts, both of the states and at the federal level, who have the greatest degree of power in this regard. Courts exercise their authority in cases involving statutory interpretation, regulatory interpretation, common law development, or constitutional interpretation. Again, that is where I would argue they have the greatest degree of unfettered power. The power of judicial review, which is most often applied to acts of Congress and to state legislatures. Hopefully this has been helpful to you a little bit as you continue to read over the next few weeks about the important role the courts play in the United States to regulate business and industry. I'll be looking and anxious to hear any comments or questions you may have when we go into our class session this week. Thank you. Until next time.